Hello, everyone, and welcome back to an ad hoc session of the Business of Compliance podcast. We are joined by two incredible minds, two incredible people in our community. Kevin Schawinski, former astrophysicist and founder of Modulus AG, and Shay Brown, also a former astrophysicist and founder of Babel AI. Kev, Shay, thanks for being here today. I really appreciate you two.
Thanks for having us.
Of course. All right. So, ad hoc session, I mentioned what is so important that we felt it was worth creating a new session out of band of our regular release rhythm. In short, we have new AI legislation that appears to be ready to be signed into law in Texas, one of the states in the United States, specifically related to responsible AI governance. Now, this bill, for those of you that have been watching, is HB 149. It's the Texas Responsible AI Governance Act, or TRAIGA. I'm not sure how to pronounce the acronym. And it sets to lay out really four key things. Responsible development and deployment of AI systems within the state of Texas. It seeks to protect individuals and groups from known and foreseeable harms. It seeks to provide governance clarity and establish institutional oversight. And lastly, it seeks to balance consumer protection with innovation, really through structured regulation. Now, that said, Shay and Kevin, I know you both have had an opportunity to review the act, and I do want to say to our listeners, this act is not yet signed into law, and it's relatively new. So the opinions you hear today are likely to change as we become more informed. But again, we felt it was worth getting in front of this just to share with the community. Again, Kevin, based on where we are, what you've seen in the act, are there specific things that we as a community really need to be concerned with or keep an eye on?
So I think the biggest innovation or biggest change that this Texas law introduces that's not really present in the AI Act from the European Union, which is sort of the ancestor of all AI laws around the world, as if they all go back to that as the origin, that it has dropped the aspect of a risk classification. So the EU AI Act introduced the concept that there's some use cases that are not particularly risky, that have lower obligation compared to high-risk use cases that need much more scrutiny, as the AI Act envisions, and even prohibits some use cases. Now, this Texas law removes that entirely. It essentially puts all AI use cases on the same level, and it prohibits certain use cases. So there's no gradation. It sort of doesn't matter what AI system you're bringing to the market, you face the same level of scrutiny.
Which I do think is interesting. And to your point, Kevin, there aren't necessarily traditional risk classifications that we're familiar with in other regulation, but there are specific exclusions or specific prohibitions on use. A few of those, prohibition on manipulation, prohibition on certain use of biometric data, on social scoring, discrimination, and then use of sexually related content, primarily in the context of protecting children and minors. Other than that, it's kind of wide open. And I don't know that necessarily is a bad thing, but I do think that it leaves space for interpretation and many questions. I mean, Shay, I don't know if you have thoughts on this.
Yeah, I think it's going to, I think as actually Kevin mentioned before we started recording, that it gives the Attorney General a lot of latitude to go after things that they think are important, or they want to make examples out of companies. And so I think that latitude is a source of risk, I think, for companies. One thing that I noticed, which is in terms of similarities, which I think is relevant for businesses, is that it does further highlight fundamental rights, like the EU AI Act and like some of the other state regulations, the more comprehensive ones. And they all use different language around that, but essentially they're recognizing that there are rights that consumers have relative to these AI systems, and that the AI systems need to respect those rights or not violate those rights.
Mm-hmm.
And the emphasis on risk management as some kind of either requirement or safe harbor in this case, or called out as a thing that is going to be limit your risk as a company in the eyes of the actual law. It's on paper, and I think that those are good signals for people who are worried about how does the US's federal stance on some of these things affect the likelihood that they have to line up with some of those concepts. It's pretty clear it's not stopping states. It's not going to stop the EU, and that risk mitigation and risk management and the respect for fundamental rights are not going anywhere. And so this is just another example of that.
Yeah, and then Shay, I don't know if you care to elaborate, or maybe Kevin, maybe both of you, a little bit on the potential safe harbor, because I think this is important. I think it's important for the community to hear, particularly those that will be bound to this new regulation.
So there's this emerging pattern in U.S. state legislation on AI that has language in it to the effect of, if you're using a certain recognized national or international standard for AI governance, then that is sort of presumed safe harbor. In the case of this Texas law, it calls out the NIST AI risk management framework and then other recognized international standards. I think in Colorado, it explicitly calls out ISO 42001 as the management system that gives you safe harbor. And I think that this is a pattern and seems to generalize. The state legislators look at it and say, we might have our own particular local state level legislation, but really what we want you to do is adopt one or a set of these international standards, and use them effectively. And then you have this presumption of having done at least your basic due diligence.
And what I do think is interesting is, as you read through the legislation, there's a bit of a conflation between purely risk management and a risk management framework and AI governance in general. And so specifically as it relates to the safe harbor, and I forget what the language is, something about the entity will not be found liable if, and then there's reference to the NIST AI risk management framework, and then reference to other accepted national or international standards related to AI risk management. But really and truly, the entire legislation is couched in the concept of responsible governance of AI, of which AI risk management and those frameworks are simply a part. We'll also see equally as important, particularly in the case of prohibited activities or AI impacts. Shay, I think you were about to say something.
Oh, yeah. I mean, I think we see this in there are a lot of, even in the most recent California, which is not a law that was passed, but a reworking of the regulations around automated decision systems and how they're applied in a variety of sort of high risk scenarios. They also reference similarly some kind of risk management, and not just risk management, but also pointing really specifically to technical testing of these systems. And discrimination obviously is a big component of that. It was brought up again here. And I think there's an interesting play where in this law, discrimination is really highlighted as deliberate discrimination. Like they really focus on the fact that it just wasn't accidental. There wasn't just happened to be disparate impact.
Right. Intent is a big word.
The intent is so what I think is going to be an interesting, I want to hear both of you, what your thoughts are on this, but in some sense, the fact that they are sort of asking for people to have risk management, which is going to include technical testing, it's going to be harder to argue that I didn't intend for this to happen while my risk management system has specific policies and procedures about testing for things like disparate impact. This has come up before in complaints to the FTC and other places where people have actually argued the presence of the NIST risk management framework in the U.S. and the public dissemination of that essentially is a reason to believe that it's a reasonable company, a person in a company should reasonably have been aware of the fact that these risks exist. And so they can't just say, we didn't know. And so I think this is we're getting to the state now where just saying that, oh, I didn't realize that I didn't intend for discrimination to happen is going to be a harder thing to argue when you have risk management systems that everybody knows about. And if you've already implemented one yourself, supposedly, it's going to be an interesting sort of dynamic there.
I think you hit the nail on the head there, Shay. I think this is, by the way, I think a difference to Europe that comes from the civil versus common law distinction. So the EU AI Act basically says you must have a risk management system. Here are its components, and here's how it should work. It gives you clear instructions what you're supposed to do. Whereas in the common law tradition, that tends to not be the way that legislation is written. And we're seeing this reflected here. Pick a risk management framework. You should you reasonably expect it to have one, and if you do, that will be recognized. And I think that's the common law approach to situations like this.
This really reminds me of, for those in the States that are familiar with the HIPAA security rule in particular, we know that OCR is responsible for enforcement of violations of the HIPAA security rule. And as it relates to enforcing fines, they'll use the concept of willful neglect. And so in instances of willful neglect on the behalf of a business associate or a covered entity, we'll see fines shoot through the roof. And so, Shay, Kev, as you all are talking about this, it kind of feels like what we're saying and what our listeners should understand is that if you are, and you should be, implementing AI governance that includes AI risk management, you absolutely have to own the outcomes of your risk management processes. You have to hold yourself accountable to doing the right thing with those outcomes and not just treat them as a brainstorming activity so that you can check a box as it relates to other compliance.
I think there's another aspect to this law that struck me. I was speaking to somebody about this actually this morning, coming from a European perspective, and I said, and by the way, did you know that now Texas also has an AI law? And the person sort of shrugged their shoulders and said, like, so what? And I had to point out that this isn't actually a special feature of the Texas law, but all these state laws in the US, the AI Act, and actually other laws in places like Brazil and South Korea and others, they're all extremely extraterritorial. So this Texas law uses language of if you're doing business in Texas, meaning if you have a customer in Texas. I think in California, they use language like if the model is available to Californians, and the EU uses if it's, quote, on the EU market. And because their AI is a digital product or service, people still have a hard time associating doing business with or being available on a market simply by having a website and it being possible for users to sign up from a certain location. And I think that increase in complexity from having potentially up to 50 state level laws in the US alone is something that is not quite yet on the radar of many organizations, just how complex that will be. And to go back to what we spoke about earlier, that the solution in most cases will be do something reasonable that scales and then see if you have any gaps that are specific to a local law. But as long as you have a reasonable AI management system in place and reasonable risk management in place, you actually fulfill 60, 70, 80, 90% of what's being asked of you here.
And Kevin, before we go further, I just want to say, and Shay, I'm sorry to interrupt, but to your point, Kevin, in the legislation as written, that this regulation applies to any person or organization that promotes, advertises, or conducts business in Texas, produces a product or service used by Texas residents, or develops or deploys an AI system in Texas. So it's fairly inclusive of any AI system that has any contact with Texas residents. Now, I do think as you talk about this distribution, this variety, if you will, of state regulations and enforcement, it reminds me of the AI liability directive and how EU nation states have had to backpedal to figure out what enforcement will look like for all EU residents. I mean, do you see that it's that same kind of chaos? And can implementing a singular management system actually help organizations make some sense, take some proactive steps forward to controlling the chaos that they're about to feel?
Yeah, I don't know. I mean, I'll just jump in here and say it is already chaos. It's not going to be chaos. I think currently companies are feeling that chaos. I think the good thing that we know as people who do this, that there are just very commonalities among all of these, and that you can align yourself with a law or a standard, and it will cover 90 or more than 90% of everything. And if you do it to a good faith version of that, where to your point, Patrick, like you actually follow through and you focus on and actually having the real intention of mitigating risk, you're covered. I think the the one thing I would say is that probably a lot of your listeners are people who are interested in implementing something like 42001, because you have, you get a very strong brand in that area. And this is just another example of this will impact how you scope out your system. Like, it has real impact. Like, if you operate in Texas and you have a system, and you're thinking about the context of your organization, a significant stakeholder now is the Attorney General of Texas, because they are somebody who can impact you financially. And if you don't have that considered, then that's a gap in your that part of the standard. And I think having that structured way of thinking through those risks is going to be beneficial, and it's going to be table stakes at this point. There's no way around it.
Totally agree. But one thing I do think is interesting, and this is more an opinion that I hope to be shot down, so please pick at this, fellas. But as I do think about enforcement, the way enforcement is declared in the legislation, enforcement is left to the state attorney general. There is a ceiling of fines for right around $100,000. So for larger organizations, I don't know that this is going to be a big stick. But because enforcement is left to the attorney general, it feels to me like there's potential for this to be leveraged, really just in instances where political ideologies are at stake or involved. Do you get any sense of that, or am I way off base?
I mean, I think you hit upon the core of this bill. So this is where it really diverges from the European approach, which is essentially consumer protection, and you must pass a certain standard in order to be on the market, and it's third party assessed, and it's a very sort of mechanical and open process. Here you have one office, one person potentially deciding whether this law applies, and that of course has a political dimension to it. There could be selective enforcement. It also, I was thinking about this today. It's a different kind of risk to an organization than something like the EU AI Act. The EU AI Act is very legalistic. It is very much a well-defined process. This is a risk that you actually cannot mitigate by technical means, because whether or not the Texas Attorney General makes a decision to investigate you does not depend solely on the facts of the case. It depends on personal decision, and that is a risk that every organization doing business in Texas, going back to who's doing business in Texas, must now consider.
And so, Kevin, I think to dovetail on that, to take a step back, where the best way for our organizations to hedge against that risk, to really protect themselves against that risk, is to build an internal management system that allows for and requires not only solid documentation, but continuous improvement in addressing those gaps that have been found internally.
Yeah. I think that's really the only thing you can do against this is to demonstrate anything that demonstrates good faith. I think that's the North Star here. Is like, there's the spirit of all of these laws are all the same. Is that there are external people to your company, consumers, and your clients who are going to be impacted by these AI systems, and there are known risks of these AI systems. So the spirit of all of these laws is that you think about that and you try to mitigate the likelihood that happens. That's fundamentally what they're getting at. And so if that is on your mind, that's the spirit of how you approach things, and that could be the more structured that is, and the more transparent that is to external people, that you actually have demonstrated good faith efforts to do that, it's going to be a risk mitigation, because there are going to be plenty of people who don't have that external or structured documentation around that, and they're much easier targets per se for enforcement, because it's very obvious that they're just totally negligent. And if you are buttoned up in good faith, that's the best protection you can have.
And guys, let me ask you this, a layer down, and I'm sorry to interrupt, Kevin, I saw you about to talk, but a layer down, if I'm an organization that's using a service provider situated in Texas or serving customers in Texas, do I inherit their fundamental risk? Do I bring that into essentially my four walls? Is that something to consider as it relates to what we might think of as third-party risk management?
So my early reading of the law, but I'm happy to be proven wrong here, is that's another aspect that seems to be largely missing from this law. It does not create this legal relationship the way some other laws do between a deployer and a provider and an importer and in categories like this. But that said, the language is vague enough that actually that may well apply. And so that is also something to be considered. It's something I talk to a lot about, especially large organizations who have hundreds or even thousands of vendors, all of whom are adding AI to their offering right now. And the organizations are increasingly worried about what third party and potentially fourth party risk am I assuming by using the email tool and the HR tool and the note taker for the conference calls. This is something that definitely is on the agenda right now.
Yeah, I mean, I think that this is you hit on the critical question, Patrick, because there are many more companies that are procuring AI systems for their use than there are people producing AI systems. I mean,
Yes.
there's obviously an explosion of AI startups, and there's no doubt about that. But the average sort of enterprise size, who are the ones that are going to be the likely targets of a law like this, are going to be procuring, and there definitely is a real worry that I don't think there's any question that they're going to inherit, even though it's unclear in the law. You can just assume that the deployer is going to ultimately be responsible, and if you haven't thought through those risks or got some sort of legally binding kind of contracts, something contractual or something in the due diligence process that's going to mitigate that risk, that's where a lot of the problems are going to happen, I think.
Okay. Guys, one of the things that I noticed in the legislation was Texas intends to stand up a sandbox for testing. Now, we've seen this in other areas. I think in the States, Utah was one of the first to have legislation that offers this. Any opinions on the utility of the sandbox, the proposed sandbox, and what it will bring to deployers or developers, for that matter, that are operating under the auspices of this legislation?
So I'm involved at various levels in a number of sandboxes in Europe, in Switzerland, and in some EU countries. And one of the challenges with sandboxes is that the definition of what a sandbox is actually quite wide open, and I see very different approaches that different countries take. But the common aspect is that by bringing a product early on into a sandbox gives the AI company, the AI startup in particular, an opportunity to test this new product in a way so that if there are issues, there are violations of the law, if this were just simply deployed, that they can test the product in a lower pressure and legally lower risk environment than if they simply place them on the market. And that can be particularly useful when we think about very, very, very risky applications and questions like HR or in, health and safety. And I think that could be very useful. Now, what some sandboxes put on top of that, and I think that could be very useful in building an AI ecosystem, is bringing the various players in that ecosystem together, supporting innovation, actually, even with indirect or even direct funding and organizing events. And so I think Texas has an opportunity here to strengthen its AI ecosystem, not just with that sort of low risk environment to test products, but also to bring the various players together.
Kevin, one of the things that I noticed is it's almost as if the barrier to entry for participation in the sandbox is greater than the legislation itself. In other words, when you look at the requirements to participate in the sandbox, organizations have to have a well thought through business plan, have to have metrics that they can abide by in the sandbox. I mean, there really has to be, in effect, an AI governance program in place before that system can be rolled into the sandbox for testing, which I think is phenomenal. It's almost as if the requirements are in the wrong spot in the legislation itself.
It's like the legislator basically encouraging Texas companies to do the right thing this way. It's good.
Yes, good. Shay, I think you were going to say something.
Oh no, I just, looking through the language around the sandbox, I mean, they do include like they do get much more specific there. They're talking about specific industries that they're targeting, like financial services and the medical field. And I think there's a lot to be, I think I agree totally with what Kevin said. I think the biggest benefit from the sandbox idea is ecosystem growth and getting clarity, giving opportunities for stakeholders to have clarity around the law and being able to demonstrate their good faith effort to comply. And I think that's going to be huge for them if they can get, because there is going to be an ecosystem. We're all part of an ecosystem around assuring these systems and making sure that they are protecting people and they also can protecting business value. And I think encouraging that ecosystem is going to be important, because otherwise it's just, compliance for, in a void, and that's never good.
And then, guys, as we begin to conclude and wrap things up with this session, just to say this. So the bill was passed through the House unanimously. The bill was passed through Texas State Senate unanimously. It should be at Governor Abbott's desk. We fully expect, based on its progress so far, that it will be signed into law. Now, one of the biggest things of note is that enforcement is set to begin in January of 26, which gives organizations less than 6 months to prepare themselves to withstand the legislation and potential enforcement by the state attorney general. What do companies need to be doing today to prepare themselves to be successful in 2026 and beyond?
I mean, the Texas deadline is now one of the closest in the world. Is closely followed by some other deadlines. And again, I can't stress this enough. All these laws are extremely extraterritorial. So I would urge all the companies to talk to in Europe to think about this Texas law, whether they will consider it a priority or not. And they should get started right now in building an effective AI governance, building a management system, and at least be on the journey towards some sort of third-party validation certification that what they've put in place is effective. And you two are far more the experts on what that involves and how long it takes than me.
Yeah. I think it's hopefully most companies have already started on this journey, but I think if they have not, then it definitely needs to start now. And because shortly after we get Colorado coming, which is going to be, Colorado law has even more prescriptive guidelines, and that's February of 26. And then EU Act is on, coming in August of that same year. So now is the time. And I think going towards a certification like 42001 does make probably the most sense at this point. Even if there will be people who will quibble about exactly how much the European Commission is going to accept it as a quality management system or whatever. We can have those fun debates, but the fact is what's available right now and what is sort of certifiable and that has the most traction and most industry adoption is 42001. And companies that haven't started that journey, first thing I have to do is assign that job to somebody in the company to be responsible for this. They have to inventory their systems, give a high level look at what their exposure might be, and then they need to reach out and start contacting people about getting prepared for this. There's not that much time. It's not an insignificant lift, depending on the size of the organization.
Yeah, and Shay, to echo a little bit of that, it is not an insignificant lift. What I do think listeners need to hear, however, is that though it feels absolutely overwhelming and that there's no good place to start, the reality is there is a good place to start, and building an AI management system is totally doable if you approach it in a methodical way. Start with ISO 42001. Again, we know from an EU AI Act perspective, there may be limited acceptance for 42001 as it relates to really directly connecting the QMS standard. We also know that because of the very nature of management systems, it's not a big deal. We simply extend the management system to meet the needs that are missing. All that to say, get started today. To both Kevin and Shay's point, get a copy of 42001 so that you can understand structurally what the framework of an AI management system really looks like, and begin evaluating yourself, warts and all, so that you actually know where to start building in a meaningful way to meet the deadlines that are coming. And to say this plainly, it is my opinion that though we see lots of regulatory pressure, the pressure that you as business leaders will see first will be from your own markets. So that is kind of this untalked about thing today, but even more reason, even more validation that you need to be building systems that allow you to approach market and market pushback in a responsible, consistent, effective way. Kevin, Shay, anything in closing before we say goodbye to our listeners for today?
I would add that there are many other states in the US, and I think we'll see rather more of this than less as politicians in other states will also want to tackle this topic because regulation of AI, no matter how you ask the question, is actually popular with voters.
Agreed. Yeah, common sentiment is we need to be sure that we're doing the right thing. I think there is no common sentiment about what that right thing is, but by and large, we know the frameworks to be responsible. All right. Kevin, Schawinski, Modulus AG, Shay Brown, Babel AI, thank you both so much for your time, for your expertise, your opinion. To our listeners, we'll add to the show notes links out to some of the Texas documentation. I'm going to link out to where you can purchase ISO 42001 should you be interested. But thank you all for your time. We're very grateful for you.
Thank you.
Thank you, Patrick.
Okay, guys, let's be sure that finishes uploading.